on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that You
have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So. Correct?
Let's listen
yes,
in, guys.
I think when
Here we
he
go.
signed it, they were outside of the 70-day, but the speedy trial
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rozzi and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rozzi on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judges. I'm aware of that. I know what's happened.
Oh, what the heck?
I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rozzi, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action, the judge. I'm going to go out there and I'm going to say these things. And Mr. Rozzi presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
Because
Your
you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Without a
those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
my
Amendment
concern is getting
required.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
A lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who are represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that yet, just no, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rozzi developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found, would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel,
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
You think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rozzi back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
That was pretty good by Richard Allen's attorneys. I thought they did a very good job. I didn't want to comment because there's a lot going on there. We'll talk about it.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Frances Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the.
God damn it, Indiana Supreme Court. Come on now.
Were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm
of
really
counsel.
struggling with that. Butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice
Shit.
Scalia and
Judge's
taking
not
him for his
fucking
word
around.
on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very...
You're arguing the Sixth Amendment is highly limited?
In the Knox case, saying a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril, and this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified,
Yes.
if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was a mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly, then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So
Well,
your
tell us why you
solution,
think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so I'm
violation.
clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What
The
about our 1982 precedent? So State versus Tippecanoe County, the shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done, there's a way that you do it. And it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that
Boom.
she presented them back in chambers saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of
So
procedure.
there's no process involved at all for taking a judge, no hearing, no, I have the suspicion.
Come on. Let's go Indiana Supreme Court. I know it's hard. There's like a million
that this is
people
going
watching.
on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts.
Squirm,
And
buddy.
They had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rozzi got together with their client and drafted a letter. On the 12th, Mr. Rozzi filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rozzi said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either. What they
Would
did
any
was
of those
withdraw.
actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
Because she said then at the hearing on the 31st, what's changed? So, which means,
Well, we won't know
do
what
know
would have
that.
happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that there's a.
Because it's judge induced the failures, brother.
have changed their mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you
and
help me
attorney work product.
Can you help me understand how that hurt Mr. Allen's defense?
Well,
It's-
believe
Thank
Mr.
you.
Rozzi. Mr. Rozzi himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel
I keep
capable of
getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat
It was
waived
a
that
major
conflict.
conspiracy with lots of different people playing, in the Wheat case.
Wheat
I don't see
himself,
Wheat as tucked as neatly as you find Wheat. So
Wheat
go
him-
outside Wheat and give me something else.
well,
Uh-oh.
Wheat
Uh-oh.
himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on
where can you point to me saying, with regard to saying somebody is incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence.
Uh-oh.
We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a
Yeah, we haven't been allowed to have hearings, you
Understand the scope of the
asshole.
Rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side. I think.
Good argument, Susan.
Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The
Because
trial
speedy
court,
trial
in
doesn't matter.
exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned there be if we were to go do it the right way. I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel, we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me
Wouldn't
offer
that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm?
We have no record. It doesn't
Because
matter.
of the necessary delays in backing up and going back through, again, reinstating counsel, and if the judge is correct, then that will weed itself out, and there'll be a hearing, and it'll be done a proper way in the trial court, and then come back up.
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interests, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will believe.
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made in the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose.
And whose fault is that it's ambiguous?
Exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to—
They're allowed to do this.
Pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice—
Yes, and it's all secondhand because we don't know what, like, the judge isn't doing it on the up and up. Yes, the judges screwed this case up beyond repair.
Representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is, in fact, the person who was making that choice, that he was, in fact, competent to make it. There's been many consistent allegations about his mental state throughout the case. And then, of course, that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule,
weighted.
something like it?
Really, you're not going to say the Sixth Amendment should control till proven otherwise?
Desire
Really?
of, a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to the all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings or ethical violations. The trick here is that we find few cases that involve
After the hearing,
multiple
yes.
different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below.
Because of the trial
I
court.
think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward.
So
if what
concerned she didn't have the hearing.
The court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But
be
there's
sufficient.
no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it
but-
could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with a larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance with counsel cases, and so forth. But it's not the.
Oh, come on. Come on, Indiana. We're almost done. Come on, guys. We almost got it. So, apparently it's frozen. Guys, the Indiana Supreme Court is probably getting hit real hard right now. Yeah, there's nothing boomerang. It's literally the Indiana Supreme Court is just... Oh, come on. For the love of God, we're almost there. We'll try to start it again. Here we go.
Envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial.
Minutes now. So we don't know. All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gull, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rozzi, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rozzi the potential impact that the distribution of these documents could have on my defense. Attorney Rozzi has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rozzi to continue to represent me until this case is resolved one way or the other.
Yes, we'll do that. Yes, come on, we'll do it. You're killing me.
Appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rozzi and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rozzi and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working
Seriously, come on.
for free, or that Mr. Allen needs to pay you, is to punish Mr. Allen and Mr. Rozzi for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client,
Come on.
he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free, or that he needs to pay them, is to
Seriously, let's go. Come on. I want to hear this. Homie is putting in work. Geez, Indiana.
lawyers are. We have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what Week is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order is something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to.
Come on. God dang it. I just want to watch this. Come on, Indiana.
Knowingly and voluntarily knows what's going on, wants to proceed forward. Yes, you can waive an ineffective assistance of counsel claim.
You can.
So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So
yes,
my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rozzi and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client, trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise,
it
the
can't.
ineffective assistance of counsel and justices, I'm not
Ugh.
But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have.
Yeah, we have a half-baked record from a lazy judge.
In the end, Your Honors, the judge exceeded her jurisdiction and refused to
I don't know how many people are watching the stream, but I
accept
bet it's
Rick
more than are
Allen's
normally
wishes,
used
and
to.
she had an absolute duty to act upon them, and there's an emergency that exists.
This is
Counsel on both
ridiculous.
sides, just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
You guys better rise too for the judge. So that's it. Richard Allen is done. They actually have a full day of arguments scheduled, so this is just one of many. So there we go. So some of you guys were wondering what was going on there. And we'll just get back to the beginning of this. Some of you guys were saying, what's the TLDR of this? T-Rex Trucking and more for $4.99. Okay. So Richard Allen is standing trial, accused of murdering 2 girls out in Delphi, Indiana. This case is like a big deal out there. There's a lot of issues with how the case is proceeded. There's a lot of screwing going on with the police and how they investigated the case. There's a lot of sketchiness in general. Richard Allen has 2 court-appointed attorneys, Attorney Baldwin and Attorney Rozzi. At some point early on, they ended up having a press conference and telling the reporters how they're going to do their thing. Oh, hold on one second. Sorry about that, guys. So Richard Allen is standing trial. His attorneys are doing their thing. There's an issue about a press conference. The judge got mad about him having a press conference because the judge just said, like, nobody talk about the case. So she had to put a gag order in. And then at some point, Attorney Baldwin had one of his former friends, a guy used to work in the office. He broke into the office. Well, he was in the office when he broke into a conference room where he wasn't allowed to be. Found all the crime scene photos, took pictures of them. Those pictures ended up forwarding on to a second party. Those then got forwarded onto a third party and then got all over the internet. Well, the one party involved in this realized, like, uh-oh, I screwed up, I'm in trouble, and killed himself, it sounds like, and, took the easy way out. It's not clear why he killed himself, but somebody died. So, oh well. And then finally, there's an issue of one of Allen's attorneys when he was typing in, one of the attorney's names is Bradley Rozzi. Well, Baldwin was typing in B-R-A-D, and he happened to have a defendant whose name started with Brandon. Accidentally sent him like an outline of how they were going to prepare some things and discovery in the case, and that got leaked on the internet. The judge, Judge Gull, determined that these guys were horrible and that they were incompetent. So she had a hearing, and before the hearing was held, she took them back into her chambers and basically extorted them by saying, if you don't quit right now here in chambers, I'm going to go out there in front of the cameras and the entire world and tell everybody how crappy you are and what you've done to this case. Now, those attorneys had a big fight with her, and this was all on the record. There was a court reporter sitting there. They ended up they withdrew from the case at that point to protect Richard Allen because they thought the judge going out there and just doing this in front of the world would really hurt his case, and it probably would have. So the attorneys withdrew as court-appointed counsel. The next week, they came back in as pro bono attorneys hired by Richard Allen pro bono. Judge Gull said, sorry, you're not allowed to do this. I'm not letting you do this. Get out of the courtroom. Because of that, Richard Allen, through other attorneys, filed a writ of mandamus, demanding, and that's where you demand the court perform or cease an action. And they performed it with the Indiana Supreme Court, saying he wants his attorneys back and he wants a judge off the case. And that's where we are today. I hope that makes sense. I hope we're caught up there. So, trying to work on that. I hope that made sense, T-Rex. So, I hope that worked. So where are we at with this right now? Let's get to some of these questions you guys had. Real quick, Rocco Rockwell's a new member. Thank you, Rocco. I appreciate your support. Unhung Hero for $2 says, I'm going to come. Don't come. Don't come. Kim Berger from 199 super sticker. Well, thank you, Kim. Now, yes, there's a big issue here about ultimately, and I think it's funny listening to the judge, because she was listed the Carroll County Court, so it was her and the Indiana Attorney General both had to do had to make their arguments. And it was funny watching these people squirm about the idea, well, the Sixth Amendment's kind of limited. Oh, wait, no, the judge's interest is more important than the Sixth Amendment. I thought that was really, really rich. You generally have the right to hire whoever you want as counsel. And this idea, and somebody brought up the question, I'm sure, trying to find if it was a question I had in time. Can judges limit who they work with attorney-wise? If it's like a court-appointed counsel, the judges keep lists. They can kick attorneys off lists if they want. But generally speaking, if I show up to court and the judge doesn't like me, well, that's a bias issue, but the judge is kind of stuck with that. If I'm a duly licensed attorney in the state, I would make the argument I have the right to be here. So I don't think the judge can do that. I think the judge is very limited in what they can, it's funny. They talk about the Sixth Amendment being limited instead of the judge's power to infringe on that being the limitation. I think that's going to get a scathing. Part of this is going to be scathing from the court saying, like, some of this is absolutely fucking bonkers. Because ultimately it is. It is bonkers what happened here. This judge on her own did this. And they keep talking about, oh, well, we don't have a record. We don't know what happened. Yes, because the judge did not produce a record. She didn't do hearings. She acted very heavy-handedly. When the attorneys trying to get this case in front of the Supreme Court ordered a transcript, the judge and her staff said, sorry, I'm not giving you one. It took an order of the Indiana Supreme Court, and the Indiana Supreme Court had to be like, listen, Toots, you're giving us a transcript. We're ordering it. That's the only way they got one. This case is completely screwed up by this judge. It is a complete disaster zone. And that's the thing. Like, this judge has ruined it. Mr. Sniper saying the judge has limited power to choose which lawyers she wants to work with, correct? Yeah. She has the limited power. She has the limited power. And I found this comment. Yeah, it's very limited. That's why, like, if I could get hired to show up somewhere in the state, anywhere in the state of Ohio, like, a judge can't say, oh, I only want judges from my county to be in front of me, or I have to know who you are. Nope. I am licensed to appear in any court in the state of Ohio at any time. And that's, well, who says so? The Supreme Court of Ohio. So that's who controls me. Saints and Makers, hi. Say, I don't think I've seen you around, so welcome. Is saying, is it common for attorneys to struggle to know when to stop talking? Yes. Yes, that's kind of how we do that. It's also a little rough when you're in an oral argument situation, because that's an oral argument. You're just getting, like, just pelted, and both sides, all the judges, sometimes they're all ganging up on you, and it's just boom, boom, boom. And you heard that question after question after question after question. Yeah, it's a little rough. Drive Me Closer saying this is one of those cases where people have wanted to see justice done for a long time, so I could see the site getting hit hard. Yeah. Normally for the Indiana Supreme Court, nobody ever watches these things. The people who watches it are the parties involved, probably. And that's about it. So if your case is getting up there and you're in a civil suit or criminal suit, those are the people who watch. So they weren't ready for probably tens of thousands of people watching this. Unhung Hero for $2, thank you, says the Indiana Steve Gosney is trying his hardest. I think he did a pretty damn good job. Ashley's saying, are they questioning, and I think she's talking about earlier, are they questioning him harder because they actually side with him? I know SCOTUS does this sometimes. Sometimes that's an issue, but generally speaking, when you're getting questioned hard, it's the judges trying to flesh out an issue, making sure they understand what you're thinking, so they understand your position better. And sometimes they just don't support your position and they're just coming after you. So it's not always a good indicator. Susan says, how could the judge determine ineffectiveness before a trial starts? Has she worked with these lawyers before? Something's off about that. Yeah, no. She's never worked with them before. I mean, and they brought it up in trial, or they brought it up on the arguments. Let's say I'm not showing up to, let's say I'm appointed to Richard Allen. I don't show up to court. I don't file motions. You know, the judge says, are you ready to talk about this? And I'll be like, Judge, I know I'm not ready. Like, when have you talked to Mr. Allen? Oh, I talked to him once so far, and it's been 6 months. That would be ineffective assistance of counsel. The judge could say, look, you're not doing a good job. I'm removing you from the case. So she can determine that's ineffective, because that would be ineffective. But it's got to be clear things like that. This stuff they did, I mean, these weren't that big of a deal. It's like oopsie poopsie stuff. I mean, we're worried about this stuff, and the state is effectively had engaged in perjury and they're hiding evidence. Like, let's get to the real struggles, the real problems. That's a shame, says, is he arguing the Supreme Court needs to be deferential to the trial court? Yes. The attorneys for Judge Gull, yes, were saying, oh, well, you need to defer to the judge. And a lot of times, yes, they will. But this is a complete review of what the judge did. And the problem is, this judge screwed herself up. She didn't make things clear. She didn't protect the record. So defer to what? There's nothing to defer to. That's a shame, says they're not going to decide this one on procedural grounds. I agree. That was my worry on this, that they were going to do actually. No, this is going to be, I think that and I don't know, that's a shame if you mentioned this, but I think they're going to send this back and make the judge have a hearing. And they're going to make Richard Allen come in, and they're going to say, like, he's going to have to effectively waive ineffective assistance. He'll probably get Rozzi and Baldwin back. But they're gonna say, like, no, you need to do this the right fucking way. Don't just do this by the seat of your pants. She's probably gonna get reamed out for that. And I don't think they're gonna remove her, as much as I'd love to see that happen. Making it less simple, David over in MLS is saying, yeah, let's just have them spend another 2 years in jail while we wait for the trial, then have the trial, have him convicted, and then spend 2 more years appealing it. What's 5 to 6 years in prison? Yeah. Now, I love that part. You know, it's easy for that attorney to sit there and say, well, you can always just appeal it. It's like, you know, if I told you you're going to sit in prison for 5 years, I think he'd say, no, I don't want to do that. I'd rather do it this way. But yes, the appellate attorney was spoken like a man who's never spent 10 minutes in a jail. Eric says, have you ever had to go through one of these before? I have done oral arguments before at an appellate level, but never Supreme Court level. And yes, one of the times it was okay. One of the times it was like, yeah, it was a little tough. And then one of the times I was just getting machine gunned. I was just getting flayed alive. So, but here's the thing. It wasn't my choice to have the argument. It was the prosecutor's choice. So I kind of had, like, once they asked for it, it's granted. But yes, it's when you're getting killed up there, it sucks. You're just like, look. You just want to stop. You just want to go, like, look, okay, time out. Look, I get it. You don't like the argument. Can I just go sit down? But you've got another 15 minutes of getting your ass kicked, so you have to take it. Scorpio 04 for $10. Thank you, Scorpio. Stabby saying, way to complete dodge a question. Hey, that's part of, you got to be able, you're dancing through minefields. Sometimes that's your job. And Susan, this is actually a very good point that if you can prove the jury's polluted, well, that's a change of venue issue. And I would make that's a very good argument. It is a change of venue issue at that point. I would have made the same argument too. Lacey says, I will say I never want to argue at the Supreme Court. I'm intimidated just watching. Well, if it makes you feel any better, if you're arguing in front of one judge, it can be as intimidating because that judge is just kicking your ass too. It doesn't make it feel any better. But I understand. Vince Clortho, new member. Thank you, sir. I appreciate it, man. Thank you for the support. And you guys and if you guys couldn't tell, Richard Allen has still not had trial. Prior to kicking these attorneys off the case back in October, they were set to go to trial actually like right now. He would have been in trial. So, let's see. Parallax says, can I hire a lawyer dog? Well, apparently it doesn't seem like. Jim is saying it was really kind of like the AG was not really fighting very hard for their side. Yeah, but they're also, I think they also realize they're in a really tough spot if they try to make the arguments they're making at the end of the day. Because normally they would say, if this was any other case on an appeal, they'd say, look, he waived his rights. He waived the right to ineffective assistance counsel. Look, he said it was okay. Why are we bitching about this? You're allowed to waive it and do whatever you want as a defendant. You're stuck with your results if you make reasoned choices. Normally, that's what happens here. So, yes, this would have been a very schizophrenic argument for them to make in hindsight. Stacy said that these elected or appointed judges, they are appointed, and I think they have retention elections in Indiana. Gene says, what happens next? The judges are going to render an opinion at some point. It'll be a little while, but it'll be soon. This is kind of like, this one's one of those ones like they got to get done pretty quick because the trial's on hold. So I think probably within the next month or so, we'll know, if not sooner. Rage says, which way do you think the judges are leaning? I think, and No Mandates is asking us too. I think they're going to say, Judge Gull, you fucked this up. This wasn't done right at all. This was disgusting. But we're not going to remove you. You weren't incompetent. They are going to say, though, but you didn't do this the right way. You need to bring everybody back. And if Richard Allen really wants them, guess what? He gets to have them, but now he's precluded from ever arguing ineffective assistance of counsel. Now, is that a problem? I think ultimately because that burns, Richard Allen's trial strategy and everything. Yes. But I do think they're going to say, yes, since he has his attorneys back, he's going to have trial within 70 days. So I think, we'll be getting ready for the Richard Allen trial probably sometime in the next 3 months or so, I bet. Yes, Lil Pill, this is also correct too. The judge wasn't allowing them to file a motion. So, they could have done this or that. The judge struck their motion. So I don't know what you want them to do. Mr. Sniper is saying, could the Supreme Court remove the judge or remove the judge from the bench is gross against the sixth? They could remove her. I mean, they ultimately have the authority over this case. Because remember, they control everything. So they have power over her. If they recused her or removed her from the bench, sure, they have the right to do that. I don't think they're going to, though, because I just think that they think that might be a bad look, and they may not think that's warranted. And yes, Suomi's got the great point. Doesn't that leave us with a tainted judge and a biased judge? Oh, yeah. She's going to have an axe to grind after getting her dick slapped like that in front of the Supreme Court. I mean, that's happened. She now looks like, and rightly or wrongly to most of any random person looking at this, they're going to say she's crooked as hell. Whether or not she really is an irrelevant issue. Like the random people, I'm assuming a lot of you guys out there thinking, Judge Gull looks really, really freaking crooked. Yeah, don't disagree with you. Will she have to recuse? No. I mean, if she was smart, she'd bail. That's a shame since we're debating whether it's a final appealable order if she removes them. I don't know how well, I don't know what your definition is here, but yes, I think you've curtailed the constitutional rights of a party. If it was removed against the defendant's wishes, yes, you've now gone contrary to his Sixth Amendment rights. I don't know how that wouldn't be a final appealable order. Because it's final in the sense that there's nothing like no more. I don't know what your guys' standard would be there. Mithril King says so they're not going to do a fucking thing. I think they're going to allow Richard Allen to keep them, but they're going to make him say it on the record in open court. Yes, I want to keep them. I don't care about any of this stuff. So. Oh, David saying, I've been in that position before where you're at the appellate level and you just want to sit down. Yeah. Yes, I have. No Mandate says, do you think the trial court judge was watching this? Yeah, I think so, or she's going to watch it later and know about it. I don't think she's not going to. Susan saying, I'd like to know why they argue there was an intimate relationship between the defendant and his counsel. Well, they talk about an intimate relationship that like they were on really good terms. They were always happy to see each other. These guys got along real well. They had the chemistry. They were copacetic. They were on the same page. I mean, they had a good rapport. It helps to have that with being, able to be intimate. You can share with each other. I mean, those things are really critical, and especially a trial like this. So that's why they're just, focusing on it that way. But yes, it is funny how they phrase it. Mithril King says this guy's rights have been so thoroughly destroyed. The only constitutional outcome is complete dismissal. Yeah, I mean, the big problem is we haven't had hearings on the state perjuring them, state officials perjuring themselves, the prosecution hiding evidence. All that stuff still hasn't been addressed. But yes, I would argue, as the court pointed out, denial of a Sixth Amendment right is a structural issue. And if you guys heard the judge saying structural, think about just like building a house, a structural defect. You're building a house and there's a structural problem. What does that mean? You're going to have to tear the whole house down. And the Sixth Amendment is a structural issue. That's a foundational issue. And if that's been violated, that's a structural problem. So that's why the judge is pointing out, the attorney was trying to say like, it's not. She's like, well, don't shake your head. She's trying to say like, no, listen, bro, this is the Sixth Amendment. You can't just say like, it's all good. No, it's not good. Vince for $5. Thank you, Vince, is saying, living 20 minutes from court, could I have watched this in person? Sorry about the internet connection. Well, if your dog was chewing on the internet cables, yes, then I forgive you. Could you have done it? Yes, but I will say that the Indiana Supreme Court recognized there was going to be very limited seating. You'd have had to have been there at 7:45. That's when the doors opened. And like there was a whole ticket, like getting a ticket, reserving a ticket thing. Yeah, there was a whole process to that. Whiskey 77 says, what will be the consequences for the judge? Well, Judge Gull is from Allen County. That's in Fort Wayne, Indiana. She is now actually like one of the head judges, like a presiding judge. So she already kind of got promoted. If it's streamed, will I watch it? Yes. Can I take off work and cover the trial? If I've already got things scheduled, I can schedule around them, but it's going to be very difficult for me to say, hey, Your Honor, I need to continue a hearing. Why? Because of YouTube. Or if I have a client, hey, man, we're not going to be able to have your thing. Why? Because I'm going to be on the internet. As much as I can, I will be available, and where I can't be, we'll catch up. Are they going to want to go to trial or interlocutory DQ the judge? I think they're going to interlocutorily disqualify the judge. And I think the Supreme Court noticed the words and here that's a shame. I don't know if your office caught on to this. They never brought up they never brought up that dangerous two-word Latin phrase of res judicata. They didn't bring that up. So I think they can bring this up, and I guarantee you the judge is going to scream "holy hell," and there's going to be res judicata arguments, and the appellate court might say that, but I think the NS Supreme Court is going to be like, there wasn't any record, so how this was improperly done. Now we're finally getting to it being properly done, so no, there is no res judicata issue. So I think that if they Bradley and Rousey get back on, they immediately just the moment she says, "Okay, you guys are back," they need to say, "And you're gone." That's how I do it. So, AD for $2, can a pro se litigant cross-examine his victims? Yeah. If you are representing yourself, you are allowed to cross-examine all the parties. Anybody who's called to the stand, you have the right to cross-examine them. So, if it's a rape case, you could cross-examine your witness or your victim. You're going to be limited to, you're going to be limited by things like if there's rape shield laws, and some states, your cross is limited to what happened on direct. In Ohio, that's not an issue. Cross-examination is open in scope. So, yeah, you have every right. I mean, you're literally operating as an attorney at that point, and attorneys aren't restricted from cross-examining a party. So, yeah. That's a shame, says that's our conclusion to your terminating a relationship. Yeah. Let me see here. Let's see. What I will say, Jim, you brought this up. They were looking at other issues. No, but the court did bring up the Supreme Court was cognizant of this. The judge sua sponte, like moving him around, the transfer orders. Though that's kind of surprising they brought that up like that. That kind of tips me off that's a big tip off to me. And I don't know the NS Supreme Court until today, knowing any of these judges. To me, that tips me off that they know a lot about this case and they're not happy with it. They're not happy with how it's been governed. They're not happy with things being done. So if I was Judge Gull, that would put me on alert that, like, somebody's not happy right now. And it's those 5 people in Indianapolis who are really fucking upset, who are kind of like my daddy. So I think they telegraphed a little bit of thought there that they are not happy with how this is being handled. I mean, these guys generally, they don't like sideshows, especially at this level. They think this is ridiculous that it got this to this point. This should have been resolved and fixed at the trial court, but they'll sort it out if they have to. So. That's a shame, says Law Talk with Mike covered a trial where the defendant fired counsel after direct exam of his ex-wife, whom he kidnapped and attempted murder. Yeah, I think it was a guy down in Florida. Yeah, and because he wanted to cross-examine his ex-wife and fuck with her. Yeah, and he ended up losing, but yeah, he's allowed to do that. He's allowed to cross-examine. So, yeah, and that's a shame, says, yes, they're paying attention. And yes, that's a shame. That's where we're talking about this. The whole issue of the Sixth Amendment right is a structural issue. Well, I think she was pointing out that a denial of counsel and violating the Sixth Amendment, that's where the attorney was trying to say, oh, well, it's the Sixth Amendment right is limited. And she's like, okay. She's like, come on now. If the Sixth Amendment's violated, that's a structural issue. So how is it really, you're going to come in here and tell me, oh, it's really not that big a deal? And she's like, don't shake your head at me. It's a structural thing. It's a foundational part of our jurisprudence in America. And I think she was just trying to say, like, no, honey. Yes, I get it. You're trying to say, oh, it's not a big deal. It's a big fucking deal. It's about as big as it gets. AD says trial judges have plenary power. To an extent, they do. That power, though, there's always a bigger fish, though. And the Supreme Court of Indiana would arguably have, they have their own power. So there's a higher power. And yes, they'll traditionally defer to a trial judge, but they're not deferring right now. They are scrutinizing what this judge did. Ray says, can you explain the perjury issues you were talking about? I don't think I'm aware of that. Yes, some of the arguments and some of the discussions made of this comes into the Odinism angle. So apparently there's, these girls were found and there were like runes, like runic symbols made with sticks near the bodies. The police kind of hid all that information. But it came out in discovery that they had contacted a anthropologist who specialized in Norse mythology and who said, yeah, this is all like Odinism related and paganism stuff. Well, defense found out about it. And then the state said, oh, well, we don't know who that, we forgot who we talked to. Yes, the police are claiming we forgot what expert we talked to. And very shortly after that, once it hit the news, the expert, the professor who did it's like, hey, that's me right here. Come talk to me. So there's some perjury issues surrounding that. There's some perjury issues, it sounds like, surrounding the search warrant. And that there are massive pieces of exculpatory evidence that are out there. So there's that. But also, I mean, at that point, once you're hiding evidence, I presume you're hiding a lot of stuff. So there likely is other things that have been hidden we don't even know about. So that's a shame. Says, I don't know why the state took an extreme position. Because that's what the state does. The state is going to be statist. That's how they roll. If they weren't, they wouldn't be good statists. I mean, the Indiana Attorney General, I mean, are they ever going to be like, look, yeah, we actually agree. This case, we're pro-defendant rights, pro-Sixth Amendment. No, they're never going to do that. It's like if they came out and said, like, look, okay, yeah, the police really did screw up the search on this case. Like, they're never going to agree to that. They're never going to agree. Brimstone says no body equals missing person, except in this case, there's 2 dead bodies, so they do have murders. So, Michael, Fidelity. I think I pronounced that right. If I didn't, my bad. I apologize. Thank you for stopping by. I'm in Allen County. Always vote no on judge retention questions. And I don't think that's a bad idea because if you live in a state where there's judges are appointed, I don't think that's a bad idea. Here in Ohio, we get to vote on our judges, so you kind of get the vote from the start. Am I covering the FinCEN targeting stuff tonight? I can a little bit if you guys are interested. But yes, if you guys aren't aware, if you have an LLC, you're going to have federal reporting requirements, and that's not a joke. Like, actually, it's a real thing. That's a shame, says, I don't think the Supreme Court has to be deferential to a trial court at all if they don't want to. Well, remember, I mean, ultimately, like, in this case, I think it's a little different, but, they do have stare decisis issues. But yes, the Supreme Court of Indiana can pretty much do whatever it wants. And that's it. I think here they should not, I think they've made it clear they're not being deferential at all to the trial court. They are completely de novoing this. They are completely reviewing this entire thing and coming up to their own conclusions. I think they're, especially at this point where the judge is sua sponte doing things. Yeah, I think they're taking the wheel. So I hope I don't sound like a moron to your office if you're all watching this. Oh, you mean the Bible buyers, the Trump supporters buy stuff from Bass Pro Stuff, Jim Jordan released? Yeah. We can talk about that stuff. Sorry. Yes, we can talk about that. Alpha Fox says this is kind of first impression. This is kind of like this is probably first impression pretty much nationally for the most part. I mean, they mentioned they had a prosecutor's office get disqualified once, like 40 years ago. But yeah, I think this is significant. But I'm also sure if I told you this was going to happen 2 or 3 years ago, you'd have been like, that ain't going to happen. Nobody's that stupid. And if you would have asked me that same thing before this case started, like here's a fact pattern, Sean. As a super chat, I would have said that makes absolutely no sense, and whoever did that would be a moron. So, what do you think it's split? Oh, I don't think it's going to be a split. I think it's going to be per curiam. I think it's going to be unanimous decision. It's going to be 5-0, and they're going to say it goes back for. Yeah, it's going to say go back. You got to have a hearing. You got to do this right. He has the right to keep him if he wants to. I mean, they're going to lay out for the judge what her limits are going to be. They're going to set guardrails, I think, and that's the thing. They're going to say, "Listen, honey, here are your guardrails. Operate within those from now on." So, oh, she says they're all back to work. Okay, well, that helps too. Guys, I'm going to work on some of those shirts. I'll put stuff together. But yeah, I think they're going to be like, listen, Judge Gull, here are your guardrails. Do it right. We're not going to say it again. They're going to refuse to remove her. Now, I bet there's a judge or two who's going to say she should be removed. And they probably will write a dissent saying she should be kicked off. This was the abhorrent. But they're not going to allow that to happen. So there'll be some dissents. There are going to be some judges who want to go nuclear, but that'll be a side issue. That's a shame. Says I was so nervous for these oral arguments. This case is a really big deal for the practice of defense, especially public defense. Yeah, it is. This is going to be really big. But I think ultimately the court's going to say, look, you can't do this, and it's so drastic that the court's going to stomp on her. So, what's the judge's name so I can look her up on Indiana.gov? It is Judge. Hold on. So here you go. It is Judge Frances C. Gull, not Judge Siegel, like caw. Not like Finding Nemo. Mine. But yes, it's Judge Gull. This is a bit of an older picture here. So yes, this is Judge Gull. She is part of Allen County, Indiana, and that's over by Fort Wayne. So she is judge there. And then looks like she is serving as the administrative judge of the criminal division for Allen County, meaning she's in charge of running things basically for the court there. So she's busy. She's going to be busy. So I'm hoping she finds a way to bail on this. That's a shame. Says we think we'll probably have a decision by tomorrow. Oh my God, that would be epic. If they do, that's if Supreme Court does it, I'm like, that's Brofist moment. I thought it'd take them a little while, but if they can do it, I mean, here's the thing: if they come out tomorrow, they're going to be like, "Yeah, why are we even? Come on now." So we'll see. We'll see. Let's see here. What else we got? Elephant. So Elephant. Yeah, I guess we'll bring it up real quick. Richard Allen is accused of murdering 2 girls out in Delphi, Indiana. This case has been proceeding to trial. In October, as a result of a couple of like mistakes, and really some stuff that was not even really mistakes, I would argue, were problematic. The judge was not happy with how the defense attorneys were going. She kicked them off the case. They tried to get back on. She kicked them off again. And Richard Allen is seeking relief from the Indiana Supreme Court, saying my Sixth Amendment rights have been violated by removing my attorneys. So that's kind of like the 1-minute version of it. So the Indiana Supreme Court just heard oral arguments on whether or not the judge had the authority to do it. AD says, it's my understanding these attorneys for the defense broke the law. What law did they break? They haven't broken the law at all. Were removed and then tried coming back using some kind of trickery. No trickery. They were appointed by the court. Okay, you're fired. You're no longer court-appointed attorneys. All right, well, Richard Allen still has the right to hire his own attorneys. And the same attorney said, we'll represent you for free. Richard Allen said, great, I'm hiring you guys. It's literally not trickery. That is Richard Allen exercising his Sixth Amendment right. So, no trickery involved. Literally a legal way of doing it. So, Luke says Molter is real new. We got to the match in 2022. Yeah. You guys are you Wikipedia doesn't know when Justice Goff's birthday. You guys are jeez. Oh. That's a shame, says they move fast. An attorney in my office argued before them in like December and had an opinion in 2 hours. Wow. Wow, they're not fucking around. Mystery Sniper says, since she removed them the second time as pro bono, do they get back to pro bono or court appointed and get paid? Don't know. I think that's a separate issue. But those guys are going to need to make money. I mean, because otherwise they're going to starve doing this. Unless it's going to happen right away. I don't know. AD says breaking in and leaking the photos. That was the guy who did it. Like that guy who broke in did that. They weren't involved in it. The guy who stole the pictures admitted, yeah, I broke into a room I wasn't allowed to be in and snooped around. So obviously the attorneys didn't break the law. Another guy broke the law. Otherwise, like a guy breaks into my house, did I break the law too? Like, no, nope. The photos were already out there too. Well, I mean, that becomes a separate issue. So that's a separate thing, but we haven't had hearings on what the state's done so far. So that's a problem. I mean, that's literally the biggest problem here. We keep having issues because the state of Indiana hasn't been held accountable for what they've done so far. All right. Okay, guys, so that was done. And since there's like 240 of you here, I was thinking we actually might try to wrap up or do all of day 3 today for Michelle Trakunis. I might start at like 2 o'clock. Actually, probably, hold on here. Actually, I'm thinking like 1:30, we start Michelle Trakunis, knock out the first part of day 3, and then we should have time to knock out the second part of day 3. Are you guys, I don't know if you guys are up for that. If you want me to start at 5, like I said, I know it's kind of short notice, but I know a lot of you here were watching it already. So what are you guys thinking? Just kind of give me an idea. Thank you, Stream Like a Boss. Infectious saying 5. Chad Daybell had his motion to withdraw hearing. You know what? Still a Thursday show too? Yes. We'll still do a Thursday show. Of course, we're always doing a Thursday show. And if you guys are new, tonight at 9:30 p.m. Eastern time, I do a live show. It's weekly. We cover a lot of stuff going on. Like tonight, we got a lot to talk about. Daniel Perry, the guy who was involved in that the headlock thing in the New York subway last year. He had updates in his case. Obviously, there's updates in the Trump trial that are going on. The Treehouse murder case apparently got really hilarious yesterday. Sarah Boone, she's a suitcase murder lady. There are some updates there. The Supreme Court of the United States had arguments that may lead to the death of Chevron defense, an agency ability to agency deference when they enact rules and regulations. And then some other stuff that's going on out there as far as the FBI and trying to snoop up private data. So that's tonight at 9:30. We start over here on this channel at that time. So if you guys are interested, stop by. I would appreciate it. It's always a fun time. And then after we have the show tonight at 9:30, we usually go about 2 hours. We usually have a after show on Locals, and if you guys aren't aware of Locals is basically like Patreon, except there aren't really any rules. They don't restrict anything, and we hang out there. So let's see here. Shepiko says I want a Locals chat so I can tip. I'll put a Locals thing up. I'll put Locals up pretty soon because it's Thursday anyway. Outfox is my channel, my choice. Yes, it's my channel, my choice, but I already told people 5 o'clock. And then if I start early, I don't want people to feel like I'm jerking them around, number one. Number two, if y'all ain't going to show up, I'd rather wait till you guys are all here. Because if it's just me fucking sitting here, that's going to suck. So, Ghazni Cellmate says, either way, I'm going to come. Okay, well, we'll do 1:30 then. All right, guys, so we'll do 1:30. The Daybill hearing is still live. They said they unsealed previous motions. Okay, well, what I'll do is at some point, I'll try to catch up on the Daybill thing off to the side, because I don't want to jump into that part way through without hearing from the beginning. That really makes it tough. Mr. Stiber says you're not alone. The Fed is in the other room. Yeah, of course. My Fed handler is always nearby, but I meant alone on here, like here alone, with you on the interwebs. Garrett Pace for $20. Thank you, Garrett. It says for your hard work and effort. Much appreciation. Thank you. I appreciate that. So we are going to go ahead and wrap this up, guys. We'll start at 1:30 and we'll get Michelle Trakunis day 3 going. Brimstone, I don't care. Don't leave the judge alone. Leave the judge alone. Do not do anything to that judge. Don't fuck with her Facebook, Twitter, Snapchat, Instagram, anything like that. Leave her alone. Do not get involved with that. I say this with 100% like emotion. Do not dick around with that. You don't need to get investigated. Number one. Number two, you don't need to fuck around with things for Richard Allen, because if she isn't mad and you guys go around there and fuck with her, I'm just saying, like, if you have it, keep that to yourself. We don't need the world seeing it and fucking with her. No, don't go to her MySpace. Don't go to her OnlyFans. Yes, this is basically Kiwi Farms rules. Don't tip the cows. Do not touch the cows. Leave the cows be. Tilly says, don't dick around. No channel get. I'm not worried about me. I'm worried about you guys, but also I'm worried about Richard Allen. He doesn't need that. So that's my bigger concern. Fleek the Beck says, if I come across her in Minecraft, it's on her. Okay. Yes, if you happen to run into Judge Gull in Minecraft, okay, I get it. You're going to cave her house in or flood it. Oh. All right, guys. So we're going to take a break. We'll start up at 1:30 with Michelle Trakunis. I'll see you guys. Okay, if I was a judge, I wanted to open fans. What would I call it? I don't know. Be a lot of robe-based pictures, though. So, all right, guys. I'll see you in a little while. Take care.